City Council Committee on Ordinances, Licenses, and Legal Affairs. Co-posted with the Committee of the Whole, met in Council Chambers Thursday, May 1st, 2025 at 6 p.m. for the purpose of discussing condo conversion ordinance. Notice this meeting was posted on April 18th, 2025 at 9:36 a.m. In attendance, we have all members of the committee with Councilor Merkel and Councilor Prosnewski, Council President Prosnewski from the Committee of the Whole. We also have Lori Stewart, the Mayor's Chief of Staff. Lisa Peterson, the Mayor's Chief of Staff. Lori Stewart, the Housing Stability Coordinator, and Amanda Chincola from Planning. And Beth Renard, the City Solicitor. So we're going to have a presentation, I think, from Lori to start, and allow the council to ask any questions, potentially move through some changes, and then we'll take public comment if we have time at the end.
Does this work? Just speak into it.
Good evening, everyone. It's my pleasure to be here tonight to give you an overview of the proposed condo conversion ordinance. As you can see from the first slide, my contact information, my email, my phone number are there if anyone wants to follow up with any questions. Second slide. The second slide is an overview of the outline of what we're going to talk about tonight. With the background, the current challenges, why we need this ordinance now. We'll talk about displacement. We'll talk about the framework of the ordinance, and then we will have questions and comments. Now we will review the history of condo conversion law in Massachusetts. In 1983, the Mass legislature adopted a condo conversion law in response to a surge of conversions. The law prevented displacement by providing certain basic protections for tenants and allowed communities to adopt greater or different protections. The 1983 law exempts buildings with fewer than 4 units. However, in 2024, the Affordable Homes Act, the law was amended to extend protections to buildings with 3 or fewer units. Also in 2024, a special act of the state legislature authorized the city to regulate conversions for buildings with 2 or more units. What are the 2 biggest challenges with the 1983 condo conversion law? The state's condo conversion law does not provide regulations for municipalities to implement it. Meaningful enforcement is not possible without devoting local staff and resources. In fact, in many municipalities that have adopted local ordinances or bylaws, the law is not enforced. Why now? There are 4 big reasons to pass this ordinance now. The state's condo conversion law is not being enforced in Salem and therefore is not effective in its intended goals of preventing displacement or successful relocation of tenants within the city. The pace of condo conversions in Salem has also steadily increased over the past 6 years, while housing costs continue to rise. Another reason is declining housing diversity. Salem is rapidly losing its 2 to 3 family housing stock to conversions. And finally, displacement due to conversion disproportionately impacts people of color. And since 1 in 4 renter households in Salem identify as non-white, according to the American Community Survey in 2019, it affects Salem a little more, a little stronger. This slide tells us how many condo conversions we've had in Salem by the year. How many have we had? From 2016 to August of 2024, 534 units had been converted into condominiums, with roughly 527 of those units previously being residential rentals. Over half of all homes in Salem were built before 1940. We know that older homes are more vulnerable to conversion, which reduces the city's rental options. This slide is about displacement. What is it and what does it do to people? When you think of displacement, what comes to mind? Do you see a family with a lifetime of possessions piled on the curb or jammed into a car? Do you see a landlord changing the locks or a sheriff forcing tenants from their homes? Eviction and displacement are forced and destabilizing. Tenants can be removed suddenly, either through formal eviction or more subtle tactics like harassment, utility shutoffs, or extreme rent hikes. Displacement leads to severe personal and financial consequences. Affected individuals may end up in shelter, in overcrowded situations, or on the streets, and they must often pay costly moving and setup expenses. Displacement also disrupts social, educational, and community connections. Families are torn from their neighborhoods, schools, jobs, and support systems. All of this leads to isolation and instability. Displacement causes significant psychological and health impacts, and it can trigger stress, depression, and health problems, all of which contribute to a cycle of poverty and hardship. I'm happy to have a longer conversation with any of you about what displacement looks like in Salem, about how painful and harmful it is, and why we should do everything in our power to limit it and to mitigate it. Next slide. This slide is an overview of the ordinance framework. The purpose, the process, the administration, the waiting period, the relocation fee, and the notice of intent. For the purpose, there are 4 issues that we are trying to address with this ordinance. We hope to decelerate the conversion rate of naturally affordable rental housing stock into condominiums and cooperatives, especially in multifamily residential buildings. We want to minimize residential displacement of renter households by strengthening tenant rights during a condo conversion. We want to preserve the supply of housing and diversity of housing options in response to demographic changes, such as smaller and older households. And we want to provide a permitting pathway for the owner of existing multifamily building to convert rental housing into condominiums. Regarding the administration, I'm going to compare state and Salem, what we're proposing. The state is silent on permitting, but we are proposing an administrative permit that would be granted by the Housing Stability Coordinator, that's me, with 1-year notice for vacant units, 2-year notice for occupied units. There will also be 2 parts of permitting, 2 stages. The conditional permit and the final conversion permit. If a tenant or an owner believes that the other has not complied with their obligations under the ordinance at any point, they may request a hearing before the municipal hearing officer. Waiting period. The state says that you must give 1 year prior to intent for every renter. 2 years for protected classes, and those protected classes are older adults, disabled, and low-income tenants. For 2 years for protected classes, and up to 2 more if they're unable to find housing in the same city or town. We propose 2-year waiting period for all occupied units and 2 years for protected classes, with up to 2 more if unable to find housing in Salem. Notices to tenants must be translated into the tenant's primary language. Relocation fee. The state says that $750 per tenant and $1,000 per tenant for protected classes. In Salem, our relocation payments are $6,000 per unit, not tenant, and $8,000 per unit for older adults, disabled, or low-income tenants, and that is to be paid within 10 days of vacating. For the notice of intent for occupied units, the owner must provide a notice of intent to the tenants, and the notice must include that the owner intends to convert the apartment into a condominium, that the tenant has 2 years from the date of the notice to vacate, contact information for the Housing Stability Coordinator and their role in supporting tenants with housing stability resources. It must also say that the tenant has the right to purchase the unit, and if the tenant does not purchase the unit, the property owner will provide a relocation fee to the tenant. No change may be made to the rental agreement except for a rent increase that does not exceed the % increase by the CPI or 10%, whichever is less. Notice of intent for vacant units. The owner must provide a notice of intent to the Housing Stability Coordinator 1 year in advance. The 1-year waiting period does not apply under the following circumstances: where the unit had been previously owner-occupied for the 12 months immediately preceding the unit becoming vacant, or where the owner is selling the unit to a family member. Permit review. Permits will be granted when all documentation required has been submitted and notice has been provided as required. Permits can be denied if the documentation is incomplete in any material respect, the owner has taken action to circumvent the state or local condominium law, including but not limited to unreasonable rent increases, reduction or elimination of services, termination of tenancy without cause, or the imposition of new conditions on the tenancy. Permits may be revoked. Any document or statement was false. Right of first refusal. The tenants living in the unit must be given the right of first refusal. They will be given 120 days or 180 days in the case of protected classes. Again, older adults, disabled, or low to moderate income tenants. They must be given the same or more favorable terms of sale than the owner would, in good faith, offer, or actually does offer to prospective arm's length purchasers of such unit, provided that such terms and conditions represent fair market value for such a unit in as-is condition. Once the owner sets the terms of sale, the owner may not sell the unit under more favorable terms for 90 days from the expiration date of the tenant's right to purchase. And the last slide is comments and questions.
Councilor Marcelo.
Thank you, Chair. I have a quick one on when you get into how much the state and the state law, how much they reimburse the tenant, when was that amount set?
When was it set?
Yeah. Was that back in 1983 that they came up with that number of $750 and $1,000?
I don't know, but I could find out for you. That's what it's at currently. I don't know what it was set at originally.
Okay, thank you.
I assume that gets to the question of the rates that we set in the ordinance. Is there a plan that this would be addressed at a future time by future council as inflation goes up or prices change?
Right now, a really good question. Right now, we've set it so that it will go up with the consumer price index.
Okay, thank you. Any other questions from the council? Councilor Merkel.
Thank you, Chair Hepworth, not being a member of the committee. Just really a comment. First of all, I really appreciate the work that went into this and really happy to see this in front of us. Losing our rental stock, we all know how detrimental that is to our Salem communities. And I just wanted to say that I appreciate the focus on enforcement, that the points made that the state, not only it's weak with how much they reimburse and everything, but the lack of enforcement was very telling as well. And also, you really dotted all the I's and crossed the T's, like no change to the rental agreement. So no workaround on all of a sudden raising the rent so you get somebody out another way. So just wanted to make those comments. Thank you.
And thank you, Councilor Merkel. I should have started off my portion with thanking you, Lori, for this presentation and the work that you put into this. I think it's something we've been talking about for a very, very long time on the council. And it is yet another example of state and national problems falling upon a municipality and us trying to scramble to do what's right for the community. So thank you for the work you put into this. Was Councilor Marcelo, do you have another question?
Thank you. Can you walk through the scenario of a two-family house that's sold and only the owner is living there? So there are no tenants, there have been no tenants for X number of years. So it falls outside of that 12-month, 1 year. Can you talk about, do they have to fill out an application? Like, what is their process? How do they prove that? How does that go forward?
So let me clarify. It's a 2-unit house.
Yeah.
And 2 to 3, and there are no tenants, just the owner?
Correct.
Well, they would still have to fill out the application, but the notice requirements would be different. I believe they would only the 1-year waiting period does not apply under the following circumstances, and I feel like what you just brought up falls into that, where the unit had been previously owner-occupied for the 12 months immediately preceding the unit becoming vacant, and there are no other tenants. They would have to do an application, submit the fee, and provide documentation going back 12 months if there were any tenants. And if there weren't, then they wouldn't have anything to submit with their application.
Okay, I'm just trying to scan through this. What we have here is a red line version, and so I'm trying to figure out what the new stuff is as opposed to what we had been given before. What's the fee again?
The fee right now is, we set it at $600.
And is there, like, how'd you come up with that number? What does it cover?
Okay. I have a whole memo to file on this, and I'd be happy to provide it to anyone. Let's see if I can find it. I can't find it right now, but let me give you some examples of what it covers. It would cover my time to process the application. What I anticipate is when someone applies, it's not just, it'll carry over because of the 2-year period and possibly the extension of more time for the renter living there. So it'll pay for my time to monitor things. It'll pay for the time of the municipal hearing officer. In the memo that I can't find, it breaks down the cost of my time. And I took an example of a woman that I worked with for a year, who I believe was in a condo eviction. And I just went through the amount of time that I spent working with her and put a time limit next to it. Okay, we have it. So the application review, first stage of the condo conversion permit, 30 minutes. Correspondence, 25 minutes. Application review for the final conversion permit, 30 minutes. Correspondence, 25 minutes. Appeal notification per tenant, 30 minutes. Prep time for appeals material, et cetera, 30 minutes. Appeal time for the municipal hearing officer, 1 hour. Municipal hearing officer prep time, 30 minutes. Municipal hearing officer decision, 30 minutes. That all adds up to 4.8 hours at $42.30 for a cost of $203. And like 4 visits would be 4 hours of my time. 30 calls, 20 minutes a call is 600 minutes or 10 hours. Do you want me to go on?
No, that's fine.
All right.
So my question is, if, thank you for that, and I would love to see that memo because it does support the number. I guess my question is, in that case that I mentioned, where either it was all family living in the 2 or 3 family that's now moving on somewhere, or if no one was there, and, you know, how does the fee still pertain? Because it seems like the condo, it's just going to go through a condo conversion. And so there is aside from the 30-minute looking at the application and understanding what the situation was, yeah, that's my question.
I see your point, Councilor Marcello. The way that I want to respond to that is by saying that things aren't always as clear-cut as they seem. I've been in this job for a little over 2 years now, and people come to me all the time and they say things, oh, it's just this way or it's just that way. And then once you dig in, it tends to be more complicated. So, your example sounds like it's really clear-cut and easy. My experience tells me it isn't always that easy.
Understood.
Yeah.
But there are homes that are going to fall into this category, that the family just sells the house and moves on. And I think it actually is somewhat common, maybe not entirely common, but I just want to throw that out there. That is something that I would have a hard time, that they would have to pay a $600 fee if really there's nothing that needs to be done except to verify that nobody's lived there. So that's
a fair point, but there would still be time verifying all of that.
Councilor Jerslow.
Thank you, Councilor Hapworth. I just had a question under administration in your slideshow here, Laurie. It says 1-year notice for vacant units. Why would you have to give a 1-year notice if the apartment is vacant?
Okay, that's a really good question. The reason you need to do that is because people will say that it's been vacant because they don't want to take responsibility for giving someone a relocation payment. So I'm not sure. What else are you looking for, Counselor?
If I have a vacant apartment, you're still making me wait a year so I can convert this into a condo. So I have no income coming in for this apartment, and I want to make it into a condo. So I have to wait a year without getting any income. I have a mortgage on the house. Why am I waiting a year to convert it where it is vacant?
Yeah. I think Amanda can help me.
Hi there, thank you. So this actually came in after talking with our peers in Somerville who have a very similar ordinance. And this type of provision was not originally in their ordinance. And what they found was landlords were evicting tenants and then saying, oh, this unit is vacant. And so that way they had a shorter time period. So this is to preclude that from happening, to make sure that the unit actually is vacant and it's not an eviction that's occurring to sort of circumvent that waiting period. And what they found was once Somerville had changed their ordinance, the number of vacant condo units drastically decreased. So that was a recommendation from our peers and why we included it in here.
But what happens when it is vacant? It really is vacant. I mean, why should you how can you make somebody wait a year without any income coming in? I owned a 3-family once, and, when we got, people moved out in the middle of the night and we didn't know for a whole month, we get stuck with that. So how can you do this, put the burden on a homeowner to wait a whole year without any income coming in if they wanted to? This is their property. I don't understand that at all.
Well,
why can't you go inspect it to see if it's in, you're paying $600 for this fee, why aren't you going out the next day and inspecting it to see if it really is vacant?
Well, I think what Amanda just said was that what Somerville found is that people weren't necessarily telling the truth. That people were claiming that they had no one there. But what I see a lot is people coming in with extreme rent increases. That's a tactic that a lot of people use to do what I call a soft eviction. So you're not really evicting me, but you're making it impossible for me to stay there because the rent, this is something I hear all the time. Rent goes up $600 and people can't do anything about it. That's a soft eviction. And those are some of the tactics that I see landlords use. I'm not saying that all landlords are bad. I work with landlords all the time, and I work with some wonderful landlords. But there's a good side and a bad side to everything. And primarily this ordinance is we want to decelerate condo conversions, but we really want to protect the renters because displacement is ugly, it's costly. I've had people make suicide attempts while I've been working with them. It's incredibly painful. So it may inconvenience some people, but another way to look at it is to say that renting real estate is a business, and it isn't always going to be profitable. And the way I view this condo conversion ordinance is sort of like providing consumer protections for the renter. Renters.
Homeowner, what about the homeowner?
Councilor Jerslow, please let Lori finish what she's saying.
Okay, well, can I?
The homeowner will make.
Councilor Jerslow, let's let her finish what she's saying, please.
Okay. The homeowner will make profit, significant profit. I'm not a real estate agent, but I do know that properties in Salem, I'm a homeowner, and properties in Salem are selling fast and for high amounts of money. We have a very low vacancy rate in the city of Salem. So I'm not really concerned about someone, I'm not really concerned about somebody making the maximum profit all the time and skirting providing tenant protections.
Can I ask another question? And how did you come up with this $6,000 relocation assistant fee?
Okay. Let me see if I can find my. Well, $6,000. I looked at 3 different sites to try to find the average rent in Salem, and they were all between $2,000 and $2,800, and it varies according to apartment size. But the low estimate was that a 1-bedroom apartment would cost $2,100 average Salem rent. So if you're displacing a tenant, the tenant is going to have to pay first month's, last month's, moving expenses, security deposit, and there may be more that goes into that. It's a significant expense for the renter being displaced.
Well, if you're moving, whether you're staying there or not, you still have your first month's rent because you're going to be paying the next month's. So you can't actually count that. If you're staying in an apartment, you already have your next month's rent. If you're moving to another place, you'll have your first month's rent because you're going to be having it anyways from month to month. So how can you put that in there?
I'm not sure I understand. If you're going to move to a new apartment, you're going to have to pay first, last, and security.
Not all the time. I have friends that own a lot of multifamilies, and they don't ask either for the last month's rent or a security deposit. They only get the first month's rent, but whether you're staying in the apartment that you're in, you're going to have your next month's rent. So you can count $2,000 off right then and there. Why should the person have to pay the person's next month's rent when they would have had it if they had stayed in that apartment?
Councilor Cohen.
I'm not done yet. I had another question.
Councilor Cohen's had his hand up for a while here. We'll come back.
Thank you.
Thank you, Chair Hepworth. I find the argument about vacancies very specious for these reasons. One, it enables people to circumvent the ordinance. If you know that you have some benefit by having a vacant apartment. 2, everyone loses. Like, you know, our rents are very high now. Why would anyone have an extended period of a vacant apartment? And 3, it's not like you have no other option. You can rent the apartment. So if it's vacant, you can rent the apartment until this time period has expired. It used to be in Massachusetts, and I don't know when the law changed, that you could only charge 2 out of the 3, first, last, and security. Now you can charge, if you're a landlord, all 3. I don't buy the argument personally that the person has this block of money that they have. Yes, they're going to need to pay rent somewhere else, but everyone who is displaced doesn't necessarily end up renting another place. In our community, people who are being displaced are generally relocating outside of Salem. And I don't find that to be a great thing, that people who are existing residents of Salem, and, you know, I think some high percentage, about 50% of the residents of Salem are renters. And I just don't buy into this argument that people just have this money laying around to afford something. In general, if people are long-term tenants, not short-term tenants, they're really not in a position to necessarily afford a higher rent. So if they're displaced or priced out of the current unit that they're in, the next unit that they end up renting could be significantly higher. I look at the 6,000 in a different way. I look at it like, what is the average price that people secure when they sell a one-bedroom condo. So, it could be more, 2-bedroom, 3-bedroom, whatever, which are going to, end up, getting a much higher return for the property owner. But one-bedroom condos are going for, in many cases, at least $350,000, at least on my street. And, I don't live on Chestnut Street or Beverly Hills or anything like that. And most of the units that have been converted to condos are going at that rate. So if it's $350,000, $6,000 is about 1.7% of what the return would be on selling that condo. So, mathematically, I'm looking at it like, yeah, if someone's paying $2,100 and they are able to secure another apartment the same size in Salem, it's going to be very difficult. And $6,000 isn't necessarily going to cover the costs because we haven't even factored in moving costs and other things. So I look at it more like, what is the ability or the burden on the property owner? And if the property owner's cost to help someone relocate it is less than 2% of what they can get in a return, I think that's a big deal, okay? I think that is not as much of a burden on them, because I do find that the burden when we have a housing crisis is on the renter, 100%. And I'm really anxious. I raised my hand for something else, and that was because I'm anxious. We should have been dealing with this. I think it's better now, but when it first came out of the Affordable Housing Trust Fund Board, we've waited 3 years to get our petition approved by the legislature. And as Lori said, statistically, a lot of people have been displaced. And there's a lot of people who are in the process of being displaced. And so every day, I'm really nervous for the people who live in our community who are not going to be able to live here. And I'm hoping at some point soon in this meeting that we can get to the edits that the solicitor has, because whether we're able to get to some kind of resolution in this meeting or in a subsequent meeting, my biggest concern in this whole situation is that we have a housing crisis. And the housing crisis burden is on renters. I have a owner-occupied property where I have 3 tenants, and, my rental income is approximately 50% of what the market bears. I'm on a fixed income myself, and yet I don't have the insecurity, the housing insecurity that my tenants will have if they end up looking for another place. So I'm sorry I don't have a question for you, but I really at some point hope that we can get to move to the other revisions, and I appreciate that.
Are there any other questions, or do we want to get to the red lines? Councilor Merkel.
Thank you. And I will make one quick statement, because I do a lot of work in this space, that I am comfortable with the $6,000 figure. Almost always when somebody has to head into, is being displaced, they head into a higher rent. I don't know many that unilaterally keep the same rent they were previously paying, and I don't know too many apartments for $2,100. I guess I'm just asking for a point of clarity, though, on the other point made about the year wait for it vacant. It sounds like for Somerville, if I'm understanding it correctly, it takes away the incentive to quickly clear out an apartment, so they don't immediately, rush to find some way to vacate the building so they wouldn't have to? Is that what made it go down? Like you said, after they did that, then the numbers of vacancies went down. So it sounds like it removed an incentive to try to clear out renters quickly. Is that what I'm understanding?
That's correct. So I looked back through my notes, and in fiscal year 2018, Somerville's condo ordinance, their applications came in, 92% of the applications showed that the units are vacant because they didn't have a waiting period for that unit. And so what they were worried about is that landlords are essentially evicting those tenants and then coming in and saying, I have a vacant unit, so I don't need to do this 2-year period. Once they tightened their ordinance and added that 1-year term for vacant units, only less than 2% of the applications, this was in 2021, but they found less than 2% of the applications were vacant. So it was just one of those best practices we learned from another community, and we wanted to make sure that, again, if you don't have any requirement in there, what's to stop a landlord from saying, I'm going to remove these tenants before moving forward with this so that I don't have to wait the 2 years.
If one had a single-family apartment and put it on the market, what is the likelihood that would remain on the market vacant for weeks or months in the current market right now? What's the likelihood that would naturally happen without a landlord purposefully leaving it vacant to avoid the condo conversion ordinance?
The vacancy rates are so tight right now. I think you can look on your search engine of choice and find there are very few apartments available. And so, it depends on the price that they listed at, but units are not staying on the market very long.
So it's fair to say that Somerville saw an unnatural behavior happening because of their condo conversion ordinance, and then this is a reaction to that to ensure that doesn't happen here.
I'd agree with that statement.
Councilor Gerslow.
Thank you. Has the city adequately examined the impact of short-term rentals, such as Airbnbs, on the housing stability in Salem? And alone in my little neighborhood, there's 8 Airbnbs. Has the city done any type of,
I can't speak to that because that's not what's in front of you tonight, and that's not what I prepared for. What I'm prepared to talk about are the shrinkage of units due to condo conversions. So,
yeah, but the Airbnbs are taking up such a big housing.
that's not the issue before us tonight, though.
Thank you.
Ready to move to the city solicitor to talk through some of these red lines?
Sure. Can you hear me okay? Oh.
Thank you.
Andy, help.
Oh, I'm sorry. Is that?
Hello. How's this? No.
Try now.
Okay.
Yep.
All right. So, thank you. I was asked to take a look at the condo conversion ordinance that was drafted, and I've made some comments, suggested changes. This has also been reviewed, and comments were received from retired attorney Mac McCrighton, who had helped Boston and Somerville, and so we incorporated some of his feedback here. So the first change that I proposed was to add a little bit more definition in the purpose section about the special act that was adopted by the state legislature for the city of Salem. I'll just go through them and just stop me if you want. Is that okay?
Do we all want to take a vote on all of these?
There's a lot.
Yeah, do right at the end, I guess. If anyone has an issue with these or questions, just raise your hand. Councilor Cohen.
Yeah, if I could suggest, Chair, if we just go through it and maybe we go through a certain amount that you feel comfortable with, and then we could vote on that.
I'll just make notes, and if we start accumulating, then we can start having votes.
Okay. And then I put the definitions in alphabetical order. You'll see those changes there. With respect to the definition of housing accommodation, they had listed some exemptions, which I I just deleted those exemptions and just added the phrase, "unit specifically exempt," as set forth in Chapter 527 of the Acts of 1983, or any amendments thereto, so that we would incorporate any subsequent changes. And I broadened the definition for a housing accommodation to reflect the terms that were used in the special act. I added a definition because there wasn't a definition in there about what it means to convert. So I added a definition for the intent to convert, and it lists things that you look to. You look to, is there a master deed or articles of organization for the housing accommodation? Has that been prepared? Have you, there's a list of them, there's 9 of them. Have the landlord prepared purchase and sale agreement, sell a condo? Have they advertised it for sale? And those are enumerated 1 through 9. And it ends with, retaining an attorney for the purposes of pursuing conversion. So I added that definition. And going
On these definitions, where were these pulled from? Were these just
Boston.
Boston?
You'll notice I just made,
Councillor Stott.
Thank you, Chair. Not being a member of the committee, I just had a question on these new intent to convert bullets. It made my mind go, will there be a communication plan to current property owners? They might naturally do these things not knowing our new ordinance is in place.
Yes, the outreach plan right now is that it'll be incorporated into many different facets of what's already going on. We will develop a flyer, English and Spanish, maybe something else if we have the capacity to do that. It'll go into new resident packets, renter package, which is something we do. We have a plan to reach out and email real estate agents, attorneys in the field, both people that would represent property owners and people that might have interaction with tenants. I can also email it to all of the landlords from the landlord fair, all of the tenants that I've worked with, and of course, press releases, things like that.
Councillor Cohen.
Thanks, Chair. Following up on what Councillor Stott said, yeah, I don't want us to depend on people who have shown up at landlord fairs or things. They're not necessarily the landlords that necessarily need the information as much as the ones who don't. But there are other vehicles like the North Shore Association of Realtors and places like that. I feel like once this happens, once the word gets out, it will spread pretty quickly. I just think that that's kind of the way it is. When I look through the 9 bullets, they all seem to be things that someone would do, to the solicitor's point, if they were going or even thinking about doing something. And in none of those cases, none of the 9 cases, does it mean that they actually have to convert, that they've actually, it's going to happen. So I think it's just really important that we do, like Councillor Stott point, that we educate the property owners as best that we can.
Can I add something?
Sure.
I also wanted to just add that we can also, we've also discussed educating the people at the Registry of Deeds, and we've already started to hear from people about property owners, real estate agents. I've had one that's been calling me for the last couple of days. He wants me to tell him what the ordinance said, and I told him it's still in committee. So we're hearing from people. Word is getting out there.
continuing on the procedures, I added in the first, number 1, that the Housing Stability Coordinator would have to be empowered to create the forms and guidelines that she would need to do to run the program. Just streamlined her title to HSC throughout. On E, I put in, with respect to the fee, the application fee, that the fee would be non-refundable unless the applicant withdrew the application before any processing happens. And then when we get under the conditional permit review, I added, instead of saying that the process ends when the notice period ends, because a lot of things can happen during that time, court action or whatever it might be. I put in that all requirements of the ordinance have been satisfied, and then you get that permit. Moving on to the next page, which is the last part of number 7. The issue came up about what happens if somebody creates a condo but they don't evict the tenant. What if there's no displacement? What happens then? So I proposed that there would be a sort of a look-forward period of 2 years, that if they turned it into a condo tomorrow, and then they wanted to displace someone the day after, it'd be this look-forward time, 2 years. They would then be entitled to the rights that are set forth in the ordinance. Again, with the final application process, I changed it to when you get your permit, when you've satisfied all of the requirements in the ordinance. And then moving on, a lot of these are just fixing the title. And then on number 11, I added the phrase that the time period set forth herein. This is when a landlord is having trouble. We don't want the permit to lapse, so we give Laurie the opportunity to give an extension to a landlord so that the permit didn't lapse if they still needed to take care of some other things that were required in the ordinance, that their permit wouldn't lapse and have them have to start all over again. Let's see, then we have section 51-5, which are the requirements. And again, I addressed the issue of what happens if you don't displace a tenant. That's in Romanet 2, that displacement language again. And then further on, just got more title fixes. Moving to section 2, condo co-op evictions. I added a phrase, a statement that when they send notices to the tenant, that they should also send a notice to the city. And then I sent a sort of short paragraph that talks about what happens again if they don't get displaced, if you don't displace a tenant. You convert. Under relocation payments, I struck on D, I struck the last phrase because you don't really have these trial dates. It references trial dates for eviction processes. You don't really have that anymore, so I struck that. And moving along, section 5, extension of rental agreements. This again says if a new owner buys a converted condo where the tenant was not displaced, the rental agreement of the tenant with the new owner shall be equal to the notice period. This is again all relative to tenants that aren't displaced. That was something that the attorney from Boston had flagged for us. So most of those changes are title changes, how to deal with tenants that are not displaced, and then adding some definitions where I thought they needed to be.
Councilor Cohen.
Thank you, Chair. this displacement language makes me think like someone converts an apartment to a condo, and it happens, and they decide to keep the same tenant there, and I'm through you to the solicitor, wondering like whether it is more important to figure out if the tenant has a lease, if it should be dependent on the lease, than if that tenant who has already had a 2-year notice should get another 2 years. I kind of think like, that a lease that's agreed to between a tenant and a landlord, should have some teeth to it. It doesn't always. But do you have an opinion about that? Because otherwise, it would end up to be a really long period of time when the tenant has actually already realized the initial notice.
Right. So I'm struggling with this, and I mentioned this to you earlier, how to address this. But the issue might be you're not planning to displace the tenant. You let them stay there. You convert get your conversion permit, and then you evict them. You've relieved yourself of that $6,000 relocation payment. You evict them sometime later.
Go ahead. Continue.
If I understand that, but I'm just speaking as a landlord. Like, they've been in my house for at least 2 years, probably 3 years. I always have a lease, but let's say it's 3 years, and then theoretically they're still in the place on day one of the next year. Wouldn't they have to have, because in this ordinance it addresses cause, wouldn't they have to have cause to evict someone? And the tenant would have some kind of standing by having been in that property for that long of a time? I'm more asking you the legal thing because, I'm really in favor of the ordinance. I appreciate the revisions. I just don't know about this, ongoing thing. At some point, the property owner and the tenant could have some issue that we don't anticipate.
Right. Again, that's the language that, just this afternoon, sort of trying to massage that and figure that out. I do need a little more study on that. I think that I indicated that to you a little earlier. Something I'm struggling with, how to figure that out. That is one of the Boston attorneys said, be cautious of this. You need to address displacement. So we were trying to figure that out today, how to massage that. So I don't know if Amanda has any thoughts on that. That's where we are.
Any other questions for Ms. Renard, or any other issues with these red lines or concerns? So I guess right now we could take a motion on these red lines. Someone wanted to accept them or make changes. Councilor Varela.
Thank you, Chair Hepworth. We still talking about this or making a motion in general?
Make a motion.
Make a motion that we move for a positive recommendation as amended to the full council.
We're still in committee right now, but
Sorry.
sorry.
Sorry. Only
Just to accept the red lines.
the amendments on the document. Thank you.
So Councilor Varela moves to accept the red line version of the ordinance, seconded by Councilor Cohen. All those in favor? Any opposed? Do we want to have further discussion on this? I asked for discussion on the red lines, so if we want to use red lines a little bit further, Councilor Morceau, or Councilor Jerslow, then Councilor Morceau.
I guess I'm still hung up on this extended 2-year, and I'm not sure if I'm convinced yet. This was an issue that was brought up by the Boston attorney.
Yes.
And they saw this in what way? Like, what were they seeing, and how often was it happening?
They were seeing, I don't know how often, but they were seeing that the tenants were purposely not displaced until after the final permit was issued.
And so the tenants didn't know that the condo conversion was
They
happening?
knew the condo conversion was happening, but they didn't get their relocation money because they didn't displace them until later.
But isn't part of the process as they're getting the condo, as they're going through the process, aren't they getting a notice that the building is being turned into condos, and they have X number of years to find a new
Right, but
place?
But in their experience, not every property owner, some kept it as an investment property, and kept the tenant for a short period of time thereafter.
But we're providing notice. I'm just having a hard time understanding the situation that.
Maybe Laurie, she's more experienced with the actual.
Let me see if I can try to explain this. So if I have an investment property and I have 3 units in there, and I give all the tenants the required notice, I do all of the work, and I tell the tenants, I'm not going to displace you. Once I turn them into condominiums, you can then rent the condo. But once the condo has been converted, what happens to the tenants' rights? The landlord or the building owner who's converted it into condominiums can then decide, I'm going to raise your rent next month by $500, $600 because I really want you gone. But if there's no legal protection for them, then they've lost their relocation payment and probably a bunch of other things.
So here's my thought on this, if you don't mind. This is a buyer beware situation. They've gotten the notice. They know that the building is being turned into condos. And they know it's no different than any other rental situation at that point, in my mind. They're renting from the landlord. They know that the building is being turned into a condo. I just, like, I don't know, where does it end, right? Like, and I just haven't spent a whole lot of time thinking about this, but it feels a little messy to me. And I get that they're trying to, I get you're trying to take care of a loophole here. I don't know.
I agree with you. I think it needs more thought. And,
Yeah.
it's just something that came up just recently that we're trying to solve for.
Yeah.
And
Understood.
So this is section 51.5B2.
Well, it's
We're hung up.
all throughout.
there were 2 or 3 sections.
It's every section from there on.
Yeah.
Can I ask Councilor Varela?
Councilor Cohen.
Just to, I know that Councilor Jerzel and Councilor Merkel want to, so I'm not contributing to the discussion. I would just ask Councilor Varela to withdraw the motion until we get through this portion.
The motion has been voted on. We can, I suppose, take a motion to negate the vote that we just took. This is why I asked if anyone had any questions or concerns about the ordinance as it was under discussion. Councilor Merkel.
Thank you, Chair Hepworth. I just want to offer, in my experience, when something goes on with a property and there's a renter, and they might hear something's going to happen with the building. I often hear panicked renters, they're selling the building and something's going to happen. I think as soon as, and I've seen, as soon as a tenant is told, no, you can stay, it's okay, we're not changing, you can stay. Even if they've seen something or they've heard something was going to happen, they go with that. As soon as they don't dig deeper, in my experience, once they're told, no, we're not changing, you can stay. And it doesn't go any further than that. I find sometimes they're vulnerable people that don't have the means to get somebody with more legal experience that can look at. I mean, Lori's one person, and this is a big city. They don't have somebody readily available for where they say, okay, breathe a sigh of relief and go back to, there are many jobs that they're working, and their busy lives. So I see this, as a workaround that somebody doing a condo conversion would just say that, would just have that conversation, and then it wouldn't go anything further for the renter. And then that's exactly what would happen. They get through the process, and the renter has lost their opportunity for the moving allowance, and then either the rent goes up or something happens and they're displaced. I just want to put it out there that I understand the intent of this layer of protection.
I'll get to Councilor Jersey in just 1 second. I think what we can do here is if there are people who are struggling with this logic and want to take some time to think it through and talk it over with Lori or with Amanda or with Beth, we can leave this in committee and come back to it and give you guys a week or two to talk it over. But Councilor Jersey.
Thank you. I have a problem if our city solicitor is having issues with this and has questions about it. I think we need to leave this in committee and explore it some more. So I make a motion, we leave it in committee.
We can continue this. Well, there's a motion to leave it in committee right now. We can continue this committee meeting until everyone's sort of had the chance to ask their questions they want to ask. But we will probably get to that moment. Councilor Cohen.
Thank you, Chair. Sure, that's a good compromise, but I do want to say this one thing respectfully, Councilor Merkel, to you. Before this ordinance, there's a lot of stuff in the ordinance about notifying people, giving them Lori's information, things like that don't exist without this ordinance, okay? And I guess I'm, except for the displacement language, I'm fine with all the other edits. I just don't understand, I know there's going to be instances where, people are vulnerable, they don't understand what's going on, and the landlord somehow uses this to do something, but they've already gone through a 2-year situation to me. And, landlords, as Lori said, there's a lot of good landlords. They have a right to, figure out what to do with their property at some point. So I just really agree with Councilor Masilla that at some point there's got to be something that ends it. I still fall back on this thing that, Lori talks about a lot, about how, there's not enough education, right to counsel, all sorts of things that people have. But one of the things that's really definite about this ordinance is the mandate to provide information and connection, to the appropriate people. So, I know there may be other discussion, but this is the only thing that I think is, I'm really not sure that I have like some kind of solid, answer to, is the displacement part.
Councilor Morsell.
Thank you, Chair. Can you, Amanda or Lori, can you kind of list the communities that have an ordinance like this already? We know Somerville, Boston.
Somerville and Boston are the main ones, but other communities like Newton, Newburyport, Marlborough, the state, of course. Those are some of the ones that have ordinances or bylaws, but really only Somerville and Boston have any teeth to it because they've dedicated staff resources to enforce and administer and enforce their bylaws.
Did you mean specifically with the displacement language or just in?
No, just anything in general, and I appreciate the clarification. So for Somerville, since it sounds like we have a lot of knowledge about Somerville and we've used some of their protections, how has the ordinance affected conversions, the rate of conversion?
Sure. They've changed their ordinance a couple of different times. They were high, and once they updated the ordinance, they dropped off, and that was the intended goal.
They dropped off, the conversions just aren't happening anymore?
The conversions have slowed down.
Okay. Slowed down because of the waiting period?
Probably. I mean, that's one of the goals that we're trying to do, is to decelerate the rate of condo conversions.
So the applications coming in have slowed down? That's what
the applications coming in have slowed down, yes.
I mean, that kind of data I would be interested in, just to know how this is going to affect things. And
I do have that. As you can see, I have a big pile of papers in front of me. We lost internet today for a little while, and I got really panicked, and I just started printing stuff out when we got it back.
Emergency printing. I think, maybe that'd be something great to bring back to the next meeting, is just conversion data for Somerville specifically, probably.
And does Boston have the same sorts of protections?
Well, they're all different. They're all very complicated. Like Somerville, for instance, has a condo review board that meets once a month. And Boston had an administrative permit like we're doing, and they're in discussions to maybe go to a condo conversion board. So there are just little elements to each one of them that I would just need to know more, like what you're looking for. I definitely have a sheet with the Somerville conversions by year.
Okay, that'd be good. If we could add Boston to that would be good also.
I'll try to get that data from them, yeah.
Yep.
I think there's probably a general will of the body to do what we can to slow conversions while striking that balance with understanding that it's going to have an impact on homeowners currently. So I think having that data just to know the effectiveness of putting regulations upon homeowners is important for us to see.
Let's make a comment.
Councilor Morcillo.
Thank you. So full disclosure, I own a 2-family home. And so I am fully aware of how this is going to affect my property. I live in a neighborhood that has a lot of 2- and 3-family homes and single families, and I've seen the housing stock in my neighborhood change drastically. The house next door to me was a 2-family, and 20 years ago, they turned it into condos, and the owner did that. He bought the house, lived there, turned it into condos, lived there a couple more years, and then sold. But since then, in the past couple of years, it's been developers who have been buying up the 2- and 3-family housing stock and turning it into condos. And so I'm not against condos. I think condos do provide home ownership and a low price level, and it is an entry point into home ownership at a time and in a place where homes are really expensive. And the 2- and 3-family homes used to be the entry into home ownership, but now because of condos, the price is skyrocketing. And so, there's so many issues going on because of the condo conversions that are happening. And so I'm trying to be very mindful of the rights of a property owner to do what they want, and to buy a 2- and 3-family, 2 or 3-family, and turn it into condos if that's what they see fit to do. But also, we need to provide the protections, because we hear all the time that we don't do enough as a city to provide housing and to keep affordability in the city. And the affordability is coming from these 2- and 3-family homes that were bought 20 years ago and have the naturally occurring affordability because of the price point at that time. And so it's this is very complicated. Like Councillor Cohen, I spent time on the Affordable Housing Trust Fund board also, and I remember during COVID spending a lot of time on this study of the condo conversions and how we can protect tenants. And really, this is what we can do to provide some sort of stability for tenants that were getting affordable units and are being priced out because of condo conversions that are happening. So I appreciate all of your work. I really do. This is a big one, though, as I'm sure you all know. This is a big one, and we just need to make sure that we do it the right way. But thank you.
I'm sorry. I did find the memo. If you want, would you want me to email it to you, or do you? Okay.
Councillor Cohen.
Thanks, Chair. Yeah, it seems like we're going to continue this, but I do want to mention two things. The main reason I support this, in hopefully a form that's similar to what we're looking at, is tenant protections. But something that has become missing, and I talked to a couple of councilors about this earlier today, is I have been the beneficiary twice in my life of being able to buy a multifamily, to be able to basically pay for the mortgage with the other units, to live in it free or close to that, and to create equity to enable me to buy a bigger and better place. And we used to, in our society, not just Salem, have a situation where like working class families, young people, whatever, could do that, create some equity and benefit from home ownership, which is, to Councilor Marcillo's point, like on my street, I think I mentioned this at a council meeting when we first did the home rule petition, I can literally see like 5 buildings, 3 or 4 families, all in one 6-month period sold for cash. Only one tenant. And I can't say I know all the people who live there, but I knew, a lot of them just even to say hi. Only one tenant is left out of like 16 or 17 units. It's crazy. And there were people who, because they knew I was a counselor or whatever, like, can you help me stay in my place or whatever? And it was really awkward. So in addition to protecting tenants, I would really like Salem to be a place that young families can like create equity by buying a multifamily. It's very hard to buy a single family, if you just look at Zillow or something, what a single family on everyone's street costs, it's prohibitive. So,
Okay. All right. We currently have a motion on the floor from Councilor Jerslow to leave this in committee. I will take public comment if there's no other further questions or comments from the council. Is there any other data that you all want to see from city staff? I think that, like I said, I think there is probably a general will that is in agreement on this ordinance and the intent of what you all want to see happen. I think we can probably all see there are compelling arguments being made on both sides on the displacement question. So just take some time over the next week or two to think it through and have these conversations, and then we'll come back to this topic. Councilor Marcillo.
Thank you, sorry, Chair. Can I also ask for some sort of like a table or a grid comparing the different communities, what the differences are?
Yeah, I have that.
Great.
Do you want to see condo conversion rates from 2018 through 2025 or whatever data you have? Yeah.
Well, I might be able
Or
to
the
get
ordinance and after.
I might be able to get data from Boston. I already have data from Somerville, but I do have a chart of the cities and towns that have them. I made an Excel spreadsheet with like what the different benefits are, what the ages are, all of that.
All right. No further comment. We'll take public comment starting on the left and moving around. Felipe. Sorry?
no chair.
My left, but if you'd like to go ahead, Steve.
No? Steve?
Whoever wants to come up, come on up.
No one over here. I'm going to help Steve, so Mr. Capanis. If there's a table here, so I'm going to guide you a little
I
bit.
appreciate it. Thanks, Jeff.
Okay.
Steve Kapanis, 23 Wisteria Street, Salem. I want to make some comments that I hope you'll take into consideration regarding condo conversion. First, the request for rates. I think you're asking the right question. You need the rate, not the number, because the data that they have from Somerville shows the number. And the reason the rate is important, hypothetically, let's say there's 1,000 three-families and 200 of them get converted. That means 20% was the conversion rate. The following year, the new base number is only 800. So if 160 get converted, the rate hasn't changed. It's still diminishing at the same rate. And all the Somerville data that I have seen is reporting in number. And the other part of that is you need to be careful of causation and correlation here. Is it truly that drove it? Is it something else that was happening in the market that drove it? Next, I want to talk about some things that are going to happen here. One, think about this for a second. You're telling the landlords, if you rent to somebody that's of able-bodied and good financial means, when you tell them to leave, you only have to give them, take care of that for a year. However, if you rent to somebody that is not of modest means, that is disabled, you're going to have to pay them for 2 years and maybe 4 if they don't find a place. So you're literally incentivizing landlords to select able-bodied people and people who are of higher means so that they don't have to pay for 2 years or 4 years. And the other part of this is there's going to be some things from the landlord, and this body is speculating what the landlords are going to do. Speculation with housing in this city has not worked. When we came up with ADUs, that speculation failed. There's less than a handful of ADUs, and almost all of them have gone to family members. The next speculation that the city made was first right of refusal. They took the time to write letters to every landlord, 2 and 3 family, saying, we want the right to buy your house. 3 people signed up for it, 3. The speculation isn't good. But I will tell you what some landlords are going to do. They're going to say, okay, I got to pay $6,000 to the people. I have a 3-family, that's $18,000. Pretty quick math. Increase my rent immediately by $200 a month. My return on my investment is only 3 years, and if I have to pay them, I'm just giving them back their money. The other thing that you're going to see is landlords stopping a lease and go tenant at will, 30 days notice. And for that exact reason that the city solicitor brought up, I can convert my 3-family to condos and not do any construction, not change anything. Keep the tenants in there, and then at a later date. I think you need to get meetings, not just with tenants, but you need to get realtors, and you need to invite the landlords of the city of Salem. You don't have to work in a silo to make this decision. Get the landlords in, send them a notification, say, we want to hear from you, we want to talk to you. We want to find out what your plans will be if we pass this ordinance. And to close, I probably should have led with this. I appreciate that you're having these conversations. I think they have to be had. I think there's going to be speculation. It's the only way to get something to move forward. But I think you can reduce the speculation. Thank you.
Thank you, Steve. Felipe?
Good evening, folks. Felipe Zamberlini, 19 Linden Street. I'm going to kind of speak on 2 hats today. First, on my hat as a member of the Affordable Housing Trust Fund Board when this was developed, and then I'll go on my personal hat because I was a former owner of a condo as well in Salem, and one that displaced people, as a matter of fact. I have an email, 5/6/2021. Your actual first email was 5/5/2021. That was the first email Amanda Chancola sent to the members of the Affordable Housing Trust Fund Board that we're going to work on doing research first. So for approximately 6 months, this body looked at policies from all over the state, and that list that Laura mentioned she has includes Amherst and a bunch of other new cities and towns that do have condo conversion ordinances on their books already. Some of them did exactly what we did. They went through the process of asking the state for a home rule petition to go ahead and say, hey, we want to be able to look at condo conversions below the number that the threshold that the state has. Most of them didn't need it because their housing stock market of multifamily housing wasn't just so many two families like we have in Salem. They could stick to the rules of the state and be just fine and adhere to their own local rules that were established. But we had to do something different. We had to go through the home rule petition process and wait for 2 legislative sessions. We are, let me make quick math here, right? 4 years almost to the date of that first email that Amanda sent out to members of the board who are going to make up part of that subcommittee, including 2 members of this council, including then Councilor Christine Midori, who's super savvy on this topic and was able to coordinate all of the data, all of this research that we did, and it accounted for all of the factors that you're all discussing here today. So $6,000 isn't an imaginary number. It's a number based on data. It's a number based on metrics that are real about people's lives and people's ability to rent. The 2-year and 1-year timeline, we're looking at the state law. You all saw today, right? The state has some thresholds of 1 year as well. But we looked at what other cities and towns were doing and what was working, and we adopted the things that were working from other cities and towns. This is not an ordinance that was come up in the back of a room in the middle of the night in the last few days or anything of the sort. This has had 4 years, almost to the date, of data, research, metrics, constant conversations. And then once we had a draft, we didn't just file it away and go ahead with it. We asked landlords about it. We asked folks in the city about what their thoughts was about that initial draft. We asked tenants for feedback, and we already got that feedback. And we went back to the draft, and we modified it, made it balance out the comments that we had already received from both tenants and landlords and other property owners throughout the city to understand a little bit better. How are we crafting this based not only on the evidence that other cities and towns can provide to us, but based on the needs right here at the local level in the city of Salem? We've done that. Then we went to the state saying, hey state, we have a draft ordinance, but we need your permission. We didn't put an order attached to this because we wanted this exact conversation to be able to have. Because if we had put an order to it, then that's all that you have. Whatever the state approves is exactly what's in law. That's not what we did. We wanted this conversation to have and just asked the state permission on the ability to regulate the conversions of condos of two units at the very least. So we got that, but that was not an easy process. Home rule petitions take time. And in this case, we have had multiple meetings with our own state legislators. We saw a change of guard in the state house. We have a new state representative that also fought for this. Senator Lovely fought for this. We had multiple testimonies in which I testified multiple times before the committees. We spoke, we sent messages and letters to House Ways and Means, Senate Ways and Means, Senate President, Speaker of the House, over and over and over again. This took a lot of effort. This is not something that's just been created out of thin air, out of the blue or anything of that sort. There's been a lot of effort done on this. I want to make sure that the effort is not, and I know none of you are delegitimizing it, but we put a little extra emphasis on this. This has had a ton of really smart policy thinkers, including Christine Midori, who was an amazing leader in this work, including some members of this council who are still here today, folks that are still very active in the housing ecosystem in Salem, who understand housing, who understand tenant protections, and worked really hard to craft this ordinance. And then Lori comes in and takes that over to the finish line right now, in addition to some of the edits that are being made in recent days to make sure that this is even more tight put. It's a good ordinance. It stands a good ordinance from when we wrote it up until now. From the preamble all the way to the enforcement and mechanisms that we made sure that this was really applicable. Now on the personal level, it will be very brief on a personal level. I bought a condo in the Point in 2008. In 2012 or 14, I honestly don't remember entirely. It's not even in the data. We can't even find a record of the actual physical record of the conversion. It's only in the actual registers of deeds. The city doesn't have data on my apartment because we weren't collecting data back then. It displaced 6 families in 2012 or 14, whenever the property owner did it. They just went away. Not a single one of them are left in the city of Salem. Some of them moved to Lowell, some to Lawrence, some to Fall River, some to Bedford, some somehow got back to Boston. But 6 families were displaced just like that. Luckily, I did get the benefit of buying eventually a condo in 2018 there. But those 6 families just got the short end of the stick. And this is an ordinance that provides that protection, whether it's a protection immediately or when the condo is converted. I do think the ordinance as amended is a good idea. I understand the concept there. I'm glad to speak to anyone about that concept if you want to. Yeah, I'll be back at the next meeting once you have more information and we see another red line. But this is a great ordinance, and I'm hoping to see it move forward. Thank you.
Thank you, Felipe. Thank you for your hard work on this. Katie.
Hello, Caitlin Halapa, 70 Boston Street in Ward 6. So this is exciting. I'm glad this conversation's happening. To me, this seems kind of like a no-brainer. I'm starting to lose track of how many times I've been in this chamber and mentioned the housing crisis. It's been more than a handful of times now. A personal anecdote, I've been in my current apartment for 3 years, I think to the day. The apartment across from me was recently vacated, maybe a month or 2 ago. And when it went up for rent on the portal, and when folks were looking at renting the apartment, it was 15% higher than what I'm paying for the same apartment. So like when people are getting displaced, they are paying more wherever they end up going, for sure. And I had a small point, Councilor Marcillo, about your question on the application fee. Personally, I think it makes sense to have one fee regardless sort of the owner occupancy situation. It sets consistent expectations, which can be helpful. And I can see a situation based off of the housing coordinator's experience that some landlords may not be completely truthful about what was happening in order to pay a lower fee. But if they've already submitted the application with the lower fee and then they found out they weren't telling the truth, then what's the process to like go back and say, no, now you owe us more money and now is there extra? So it seems like a lot of work for maybe a couple $100. And then one hypothetical question, and this may have an easy answer, but it's about this 2 years forward bit thing that folks seem to be struggling with. I'm just curious if, let's say this ordinance gets passed without that part that folks are unsure about. What is the situation if the landlord's saying that they won't be displacing the tenants, they'll convert the units to condos? Can the tenants say, no, I want to leave and I want the $6,000? Are they allowed to take that? Because otherwise, is all the landlord have to do is just lie and then say like, no, I'm not going to displace you. It's fine. Trust me, bro. You can stay. And then the next day say, just kidding. Good luck. You're on your own. I think the comment was buyer beware. Just want to make sure that there is that transparency and that they do have options, because that seems like a giant loophole otherwise. So that's it. Thank you.
Thank you, Caitlin. Councilor Marceau.
And I'll make we already have a motion. I'll second the motion first because it needs a second to keep it in committee. Just to get back to the comment about the amount of work, no one is questioning the amount of work. It's been years. I've been part of that. Councilor Riccardi's been part of that. Sorry, Councilor Stott, she was Riccardi back then. And Councilor Cohen has been part of that work. The thing is, not everyone on the council was, and we need that data. We need all of that information that we went through in the Affordable Housing Trust Fund Board. We're going to be getting questions from constituents, right? And we need to have that information to make the best decision on the ordinance and to answer questions. And we can get it all into one spot and point people to the information. That's a huge benefit also. So I just wanted to make that point. There's been a ton of work, and yes. So seconding the motion to keep this in committee.
Councilor Stott.
Thank you, Chair. Not being a member of the committee, can I just follow up to that for transparency of the information? Can we make sure the red lines are provided electronically? This was the first time I saw them. And then any data that we do receive, can we put that on the shared folder so not just us, but the public can view as well?
Any other comments? Okay, we have a motion from Councilor Gerslow to leave in committee, seconded by Councilor Marceau. All those in favor? Any opposed? Matter carries. And then one more motion.
Motion to adjourn.
Councilor Marceau moves to adjourn. All those in favor? Adjourn. Thank you, everybody.